it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, it's just JV it. Like, what the hell is that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property that'll be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, welcome to the show. Today we're talking about buying commercial properties subject to. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on YouTube, you can find us on Facebook, and you can find us on X, formerly known as Twitter. You can find us on @InRem Podcast. The handle is @InRem Podcast. Also, if you want to download an audio version of the podcast, go to Spotify or to Apple. You can download an audio version for free. Leave us a review. We would appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is actually focusing on an issue that I'm seeing come up over and over on subject to transactions where I'm being consulted or brought in after the purchase contract is executed, and I'm then reviewing the purchase contract and trying to figure out all the different moving parts for the transaction. And the issue that I'm seeing is not properly outlining the purchase price and not properly outlining the amount of money to be paid to the seller from the transaction. And what I mean by that is when you're purchasing a property subject to, you may or may not know the purchase price depending on how you structure the transaction. So for example, let's say that your purchase price is going to be $500,000. There's an existing loan for $400,000. That's the original principal balance of the existing loan as shown by the recorder's website. And then you're going to be bringing $100,000 to the table and paying that amount to the seller. And the idea is that your cash at closing is going to be $100,000. It's not going to be $105,000, $110,000, or otherwise. It's going to be $100,000 cash at closing. And so let's say hypothetically that you go and obtain a payoff for that existing loan, and that existing loan has a payoff of, instead of $400,000, it has a payoff of $380,000. Well, if that purchase price is a static purchase price and is not structured in such a way that it adjusts for a lower payoff of the existing loan, well, then somewhere you have to make up the difference. So you either, and that's likely, you're going to have to bring an extra $20,000 to the table to bring up the difference to get to that purchase price if the payoff's 480 or 380, excuse me, instead of 400. And now you're stuck, like, what do I do? And so you have basically two options. You can do an amendment with the seller if the seller will sign it, which basically adjusts the purchase price downward to adjust for that $20,000, or you bring in the extra $20,000 to the table, which you didn't plan to bring in. You plan to bring in exactly $100,000 to, plus whatever costs are allocated to the buyer to close the transaction. So you have to structure the purchase price and have clauses in there that deal with these scenarios. So first, your purchase price should be the payoff amount of the existing loans as of close of escrow plus the cash at close of escrow amount, or plus the earnest money and the cash at close of escrow amount. Or you should have a clause in there if say the seller is going to net an amount from escrow, like there's an amount that the seller is supposed to net, like this is what the seller is going to be paid after everything's said and done. You should have a clause, a net to seller clause, which basically says the seller will be paid this amount from close of escrow only, nothing less, nothing more. And the purchase price and cash at close of escrow amounts shall be adjusted so that the seller nets exactly or is paid exactly this amount from the close of escrow. You need to have those clauses in place. And if you don't, then you have a problem because you have an ambiguity in your contract and it can't close. And now you're going back to the seller trying to get an amendment done. And unfortunately, I've seen this where the seller's like, no, I want the extra money at closing. You know, I'm not going to sign an amendment. So then you have an issue and you have to figure out how you're going to handle it. And I've seen it where it's, you know, unfortunately costs my clients money because the seller won't play, but they're play ball and negotiate, not negotiate, but sign an addendum to effectuate really what the intent of the parties was, even though it wasn't properly documented. But I've also seen the seller execute the addendum at times as well, but it's a problem and it holds up closing and it has to be dealt with. So my advice is, and you know, my legal update is this: if you are doing a subject to, please don't just willy-nilly fill out the purchase price information and the subject to, you know, seller financing information and the cash at close of escrow, the earnest money information, and just assume that it's all going to work out at closing. You really have to think through the transaction and say, okay, when it comes to close, what exactly is happening here? And you have to properly outline that and document it. And, you know, it may just involve simply consulting with an attorney prior to filling out the contract and saying, okay, I need help figuring out this purchase price so that it does what I want at closing. Or I want the seller to receive X amount of dollars. So what do I put into the contract to ensure that the seller receives that amount and that all other numbers are adjusted so that that seller receives that amount, nothing less, nothing more from the closing. But if you don't do that and you just willy-nilly use maybe a form that's, you know, not set up for a subject to transaction and you try to modify it, or you even use a form, but you don't know how to fill it out correctly, you're going to end up costing yourself money, or the buyer's going to end up costing themselves money. So my advice is please think about the purchase price. And it seems like a simple thing, like we'll just fill it all out, but it's not. It's very complicated if you have a number of moving parts that need to be dealt with at closing. Fill out the purchase price the right way, structure it the right way so that the transaction can close properly and, you know, close based upon the actual intent of the parties.
All right. Thank you, Sean, for the legal update. A couple reminders for the listeners. The Creative Finance Collective is this afternoon, every Tuesday afternoon at 3:00 p.m. Arizona time. So what is the collective? That is a meeting, an opportunity for lawyers in the space of creative finance to get together and to discuss all issues relating to creative finance. We get together, we talk about what we're seeing in our respective states, our respective jurisdictions, find out how we can make our forms better, how we can service our clients better. But it also provides an opportunity for you, the listener, to be a part of the collective and interact with us. And we make ourselves available for the entire hour of the show. It's 1 hour. We have a hard start and a hard finish, but we make ourselves available. So if you have any questions, been wondering about what this looks like for you in your pursuit of investing in creative finance, we're here to talk about it. And it's really an awesome opportunity for you, the listener. And we really enjoyed it as attorneys because it's how we steel sharpens steel. That's how we sharpen our craft and get better at doing what we're doing. So make sure to join us at 3:00, the Creative Finance Collective today. Three platforms: YouTube, X, now known as Twitter, and Facebook. You go to there, it's streaming live, free to you. Make sure to be a part of it. Also, we're taking questions today. So if you have questions, make sure to post them. I'm going to turn it over to Mayu, who can give you instructions on how to go about doing that.
Thank you, Andy. So good morning, everyone. Today is Tuesday, and as you know, we are live on the InRem podcast. Are you in the driver's seat? Today's topic, we're talking about buying commercial property sub 2. And if you've joined us before, you know that Andy, Sean, and our guests do take questions live on the show. So if you're watching us live, whether it's from our Facebook or YouTube pages, just know we are monitoring the chat for your questions. If you have a great question in mind, don't wait, drop it in the chat. We usually take about 10 to 15 minutes at the end of the show to get to all of them. So like I said, don't wait, and we'll try to get to them all at the end. I'll turn it back to you, Andy. Let's talk about today's topic.
All right. Thank you, Maya. With that, we're going to get into our topic today, and we are talking about creative financing, and creative financing specifically with regard to doing commercial transactions and what that looks like. And we want to go through some of the differences of commercial transactions and residential transactions and what you might expect in doing that. So with regard to subject to and creative financing, Sean, we spend a lot of time almost entirely talking about it in the context of residential properties, not so much in terms of commercial properties. So let's get into some of the differences and what an investor might expect to see. So one of the big differences, I think, that an investor might not appreciate about the commercial transaction as it differs from the residential transaction, because what an investor might think without jumping into the commercial space is, wow, the money's bigger in commercial, right? So if I can do this in residential, I can do this in commercial. The money's going to be a lot bigger. Well, that's correct. The money is bigger in commercial, but it's not necessarily easier. And one of the biggest differences is the length of the loan itself. Because in a creative finance transaction, at the end of the day, that's what we're after, taking over what used to be a pretty affordable loan as compared to what the loans are being offered now. So why don't you explain for our listeners some of the differences in a commercial loan versus a residential, and one of those being the length of it.
Yeah, so there's a few differences. Like you said, length of loan. So an acquisition loan could be, 10, 15, 20 years. It just really depends upon, the underwriting and that type of thing. But it typically is not going to be your 30-year home loan. But they can stretch it out a little bit. Sometimes though, it could be as short as 5, because commercial loans, you tend to be dealing with a smaller lender. You're not dealing with these large, mortgage brokers who are going to then, have the loan sold and securitized and that type of thing. And so, the underwriting tends to be on a case by case, property by property basis. And you also have, if there's construction loans. So a lot of times, commercial involves the initial construction of the building on the property and that type of thing. And on those construction loans, they can roll over into permanent financing, but in that case, they're generally like 5-year loans. They're very short time periods to repay. And so it gives basically the owner the ability to construct, to get up and running, without having to go get new financing, with the hope that, especially if it's like a invest or a income producing property, such as, a bunch of office space for rent, or a strip mall or something like that where you're renting. In that case, it gives them a chance to fill the spaces and to basically prove up the value of the property that way, so that they can then refinance out of it. But it's not designed for, a long-term type solution. So a lot of times you're dealing with loans that are of, shorter length.
Well, I think a lot of times people confuse amortization with the term of the loan. So, in a residential context, right, it's always like the term of the loan is what it's amortized at. If it's a 15-year loan, it's amortized, your payment's amortized over 15. If it's a 30-year fixed, right, then it's amortized over 30. In commercial loans, the term of that loan might be very different than what they've amortized the payment on, correct?
Yeah, that's exactly right. And that's a good point. So, you can have a 30-year amortization, but a 5-year balloon. And so, the maturity date does not always align with your amortization schedule. Unlike in residential settings, the amortization generally aligns with, the length of the loan or the maturity date. The other difference is interest rates. Interest rates tend to be a little higher on commercial than residential, so that's something to consider. And then this is one of the big differences is that in residential, you hear about your Fannie Mae, Freddie Mac, FHA,
Right.
VA, and the securitization of these loans so that you have these massive portfolios of loans that are, owned by hundreds of thousands of individual investors that own a very small percentage of that loan portfolio. And so, they're not really that vested in whether or not one or two or 100 or 1,000 of those loans, are still the property still owned by the original borrower. Like, are the payments coming in? Yes, the payments are coming in. That's great. And they're going to keep that loan going because those payments are coming in versus commercial. In commercial, you have a situation where a lot of times those are portfolio loans. So the lender is more vested in the property, in the transaction, making sure that the property still remains in the name of the borrower. So you do have a little bit more of a due on sale clause risk with commercial. Now, what's interesting is in Arizona, and there's a number of other states, California being one of them, that have this old line of authority dealing with due on sale clauses. And we have a Supreme Court case that basically states, an Arizona Supreme Court case that says, hey, lender, you are not allowed to invoke your due on sale clause as written. Instead, we're going to imply or put into your due on sale clause, basically rewrite your due on sale clause that says you can only enforce the due on sale clause if you can prove that your security is being jeopardized as a result of the conveyance. And so, that basically puts on the lender the burden to come into court and prove that the buyer is, a significant credit risk, is not the same as, same credit risk as the original purchaser. Well, if the borrower, were single asset entities, how would there be a different credit risk, right?
Right.
I mean, if the owner of the property was a single asset entity, which most commercial, buyers are sophisticated enough to go out and form an LLC, and that LLC owns that one piece of property. So if the subsequent buyer is a single asset LLC, what's the risk? The other thing is if they argue, well, we had personal guarantees in place on the original buyer, and we need to make sure that, the person that's taking over the loan, is just as strong and capable. Well, wait a minute. Let's talk about this, because the personal guarantees don't go away on subject to transactions, right? So if the lender is making an issue of personal guarantees and the strength of the borrower and its principles, of the new owner and its principles, well, that doesn't make sense, because you still have personal guarantees that you can pursue on the original loan. And so it really makes a tough case for a lender to go in and prove this. Now, in the residential context, that case law is no more, because we have the Garn-St. Germain Act, which came out and basically said, hey, look, for residential property that has a federally insured loan against it, state of Arizona, state of California, any of these other states that have this case authority, we're preempting you. We're taking it over. We're the feds. We're stepping in and we're saying, nope, you cannot do this. And your courts must enforce the due on sale clause as written. No adding an extra requirement into the due on sale clause like you previously did. But the Garn-St. Germain Act only applies to residential property. It doesn't apply to commercial. So you still have this line of authority out there that would be applicable to commercial property, at least here in Arizona, that really puts a burden on the lender to prove that their security is being jeopardized as a result of the conveyance. And it's a difficult thing. In fact, our court said, without us implying this requirement into the due on sale clause, we believe that the due on sale clause would be an unlawful restraint of alienation. That's the language of the case. So they've basically said, no, you have to prove this. And so in commercial, things become, in my view, a little bit more interesting. Now, if I'm a buyer of commercial real estate subject to, do I want to litigate the issue? I'm not sure, right? Because that's a lot in attorney's fees and things like that. But nevertheless, it is something to consider and give some strength to the idea of, like, if a lender gets upset and says, "Hey, you violated my due on sale clause on a commercial property," you could go back and present this case authority and say, "Okay, well, why don't we work something out and let me assume it then formally, instead of you having to go into court and prove this point." So it gives you some negotiating leverage in the commercial setting that you otherwise wouldn't have in the residential.
Yeah, I mean, if there's a disincentive to you not to want to litigate, there's a disincentive to the lender to call the loan due if it
Mhm.
means they've got to litigate, right? So, so it sounds like what you're saying, given the Arizona case authority, it may be more favorable in terms of your risk with regard to the due on sale clause.
Yeah, so I think in my opinion, in commercial, the risk is, number one, these lenders are going to monitor the loans more than what you find in residential, because you don't have these large you know, um, securitized loan portfolios.
Right.
And so you have more of a risk that the lender is going to maybe reach out and approach the borrower, approach the new owner and be like, "Hey, what's going on here? Why did this transfer?"
There's a higher risk that in a commercial context, they're going to know about it.
Correct.
Right. That's
Yes.
the issue.
Yes, that's the issue. But I think you have strength in being able to go back to the lender and say, "Well, lender, what about this line of authority? Can you show us before you go and accelerate here? Can you prove and show to us that your security is being jeopardized by this transfer?" And I think it would be a very hard thing to do.
Interesting. Well, what about with regard to the language of the due on sale clauses themselves? Have you seen in your experience a difference in the due on sale clause and how it's worded in a commercial lending instrument versus a residential?
Yeah, what I've found in a due on sale clause on commercial is it's actually going to be broader
Mm,
than what you find in, say, the Fannie Mae, Freddie Mac, or FHA due on sale clause. They're going to limit or put in there restrictions generally on leasing the property that you don't find in the Fannie Mae, Freddie Mac, or FHA. And in the for Garn St. Germain, the um, federal law states that a lender cannot invoke their due on, or put a provision in their due on sale clause and enforce it for any lease less than 3 years. So you can lease your property up to 3 years on the residential setting and never have a due on sale clause issue. In commercial, lenders are going to put in there generally, limit the ability of you to lease the property in its entirety. So if you're generally, unless, it's there's an exception or something like that, or the whole purpose of the property is to, be a rental and the lender knows it from the beginning. But generally, if you're an owner operator of a property, they're going to have a provision in there saying, well, no, you can't lease it for more than, say, 2 years or something like that. They're going to probably have a provision in there that you can't put an option against it, or right of first refusal, or different things that you would maybe be able to do in the residential context without triggering the due on sale clause.
So, one of the advantages it would seem in a commercial deal as well that would be different in a residential are that there are oftentimes different types of assets that you might have an interest in, right? In the residential case, it's the house. That's it. Now, I might want to do a lot of different things with this house, whether it's a rental or some other thing, but there aren't other types of assets that I'm acquiring with the house as a general rule. That might not be the rule with commercial. What are your options there in terms of commercial? Because you can do a lot more than buy a real estate sub too, right?
Yeah, and so a lot of times, commercial transactions come with an existing business,
Mhm.
right? So, um, one and it falls within the commercial, space. But one example is multifamily housing. You have an existing apartment complex on the property that is being operated by the owner. And so when you purchase that, you're purchasing and acquiring the leases, any personal property that was used in the operation of the business, any potential employee contracts. I mean, all of that is coming with your purchase, potentially, depending on what you state in the agreement and what assets are being acquired and what assets aren't being acquired. And so yeah, commercial comes with that. You could have somebody who is operating a retail space somewhere. They own it and they have a store sitting on the actual property. That's commercial. And so the highest and best use of that property at that moment is operating that retail store. So you want to keep that in place.
Right.
So maybe you're buying the retail store and the real estate as well. Storage units is another example of, where you're going to be buying commercial property, but it has an existing storage facility on it that operates. And so all of that are things that have to be considered and, are outside of the realm of what you generally find in the residential space.
Yeah. All right. Well, we have a guest that's joined us and has been having trouble getting on, but I think we have him. Maya, why don't you bring him forward? Jeff Watson, can you hear us? Jeff, are you there? I'm not hearing Jeff. Anybody else hearing Jeff?
Audio doesn't seem to be working.
All right. Well, we're working on bringing our friend Jeff Watson, attorney out of Ohio, in, and if we can bring him in, we will. But he's been having technical difficulties, so we'll keep plugging away. So, Sean, I say you preach. Any good lawyer preaches. You specifically, in some of your legal updates recently, have been preaching about subject to. It's about the documents. So much is about the documents. And subto purchase contract. Boy, that's just about everything to make sure that you get that right. But commercial deals don't always start with the purchase contract. A lot of them, almost all of them, start with a letter of intent. I think it seems to me that in a world of where you need to disclose when you're talking about subject to, because that's really everything. That's not just some boilerplate provision that you're just going to add later on. It really forms the nature of the transaction in large part. I sure think that's got to come out in the LOI, right? When you start that out and present what this deal is going to look like, I think that and those disclosures probably have to come right there within that. What do you think?
Yeah, at a minimum, the LOI needs to state exactly how the financing on the property is being structured.
Right.
So it needs to define the purchase price, explain what loans are going to remain, what loans, if any, are going to be paid off, what cash is being brought to close. All of that needs to be laid out in the LOI. And then once you have that LOI in place, then your purchase contract needs to be well crafted and drafted to reference and reflect all of that information. And then in the purchase contract, I would do a subject to addendum where the parties basically acknowledge, the nature of the transaction, that these existing loans remain, what the risks are. Now, the thing about commercial as opposed to residential is you're generally dealing with a seller that's an LLC, that's an investor, that's experienced with real estate. And so you may not need as detailed disclosures, in that case, as dealing with, say, a consumer seller on residential real estate. But you still have to have the disclosures so that the seller fully, is aware of and acknowledges, yeah, I understand, that these loans are going to remain. They have due on sale clauses. There's a risk, that the lender invokes it, that things may have to happen, and we may have to restructure. We may have to do something on the back end to fix it if the lender, invokes the due on sale clause. But it really does start with the LOI. The LOI should not, if existing loans are going to remain, those existing loans should be stated in the LOI.
And speaking of specificity, I mean, one thing is for sure about commercial real estate transactions, the due diligence period is way longer.
Oh, yeah.
It's way more significant. You know, we talk, Arizona's not a lawyer closing state. So we're not brought in and typically in closing just a standard residential transaction, but we sure are brought in on a commercial transaction just because of what goes on in the due diligence period of a commercial deal. It would seem to me, and you mentioned this, but I think it's worth noting again, the specificity in your letter of intent on what you're taking subject to.
Mm-hmm.
I could see a situation where if you're not careful with your language and overcommitting what subject to means, it might mean a lot more than you think it means if you're not specifically identifying, you know, which loans we're doing. Because there's, you know, when you get into the environmental, the entitlements, all that kind of stuff relating to there's a lot of things you probably didn't mean you were taking it subject to, right?
Correct. Yeah. And you need to make sure that it's, you know, outlined. Yeah, I'm taking it subject to existing loans. And then you're still going to want to have your title commitment review opportunity, your ability to provide title objections. So in the residential setting, sellers have the ability to object generally to title commitments within the purchase contract. Not sellers, buyers have the ability to object to the title commitment within as a right under the purchase contract. They just never do.
Mm-hmm.
In commercial, you do every time.
Yeah.
You clean up that commitment to the best of your ability, and you ask, and knowing that maybe on some of this you'll get no, but maybe on some of it you'll receive a yes, and then you try to clean it up and you try to make sure that, you know, if you are getting any type of financing that, you know, it's going to meet with the lender requirements. But even if you're taking a property subject to, you know, you're going to want that period where you have the right to object to items on the title commitment. You're going to want to do potentially a survey. Now, a survey may not be as critical if you're only doing seller financing, but if you want, say, extended coverage title insurance, normally the title company is going to require a survey, and that gives you, you know, better protection. You're going to want an environmental, you know, is this property that you're acquiring, you know, a site, you know, a hazard,
Right.
which then you could buy a commercial property and be like, yes, I got it, you know, only $50,000 out of pocket, and I seller financed everything, and you're all excited, and you walk in and it's a super fun site.
Yeah.
And next thing you know, the feds are like, that'll be $1 million. And you're like, what? All of a sudden that deal's not as good as you thought it was. Right.
Yeah.
And so you want to do an environmental, and then you have entitlements. Now, if you're buying, say, an existing business, presumably it's already been entitled, right? Because it's operating, and assuming they haven't been getting notices of violations from whatever authority, municipality it is. But, and you can go, you know, online generally, at least here in Maricopa County, and figure out what it's zoned and make sure that the how it's being operated meets the zoning. But there are times where, especially when you're buying land, where you're like, oh, I want to use it for this, or I think that it would be more valuable like this if I can get it rezoned.
Mm-hmm.
So you have entitlements, and that's going to slow the closing period, because you don't want to go and close only to have the county or city or town tell you, well, no, you can't use it that way.
Right.
So you have entitlements, you have lease reviews. So you have a commercial space with, you know, leases in place, and you're going to want to review those leases to make sure there's nothing in those leases that are going to come back to haunt you. I actually had a commercial transaction that was interesting, where it was basically a sell with a lease back. And so you had this seller that sold like 5 unrelated parcels all in one shot to this buyer, with the idea that the seller would then lease back all 5 of those properties. So they went and negotiated leases. And so the seller negotiated in the lease a provision that said, hey, if there's a landlord breach on one of these leases, I have a right to fix it myself and deduct my lease payments on all of these other leases. Okay. Okay, that's fine as long as it's the same owner on all 5 parcels. Well, this owner decides that they're going to sell my client one of those 5 parcels. So I get this lease and I'm looking at it and it says, oh yeah, I can deduct from my rent problems that I'm having on this other property that my client doesn't own. And so I read that lease. I'm like, no, we can't close like this. And so we had to go back to the owner and say, no, this can't be in here. You have to go back to the tenant and negotiate with the tenant and basically remove that provision, because we can't have the tenant offsetting our rent based upon, you not maintaining another property. It's those types of things that you have to be on the lookout for. And you have to make sure that, you can live with the lease provisions when you close the transaction. And that's part of the due diligence that you a lot of times won't do on residential. Financial review, right? So you have financial review where you have an existing business. So you want to make sure that, hey, is this business performing? What are the profit and loss statements? What are the tax returns? And you don't want it just for that year where, maybe they've had a good year and it's an anomaly. You want to go back a few years and you want to review all of those financials. So long story short, say a 45-day due diligence period on commercial is tight.
Yeah.
Versus like residential is 10 days. It could be done in 45 days, but you have to be Johnny on the spot, getting, all the work done, getting all the documents, that type of thing. And now what's interesting with commercial is I actually have had a commercial property that I represent the buyer and we closed, maybe a year ago or something. It was in escrow for 4 years.
Wow.
Now, with that said, part of it was COVID.
Okay.
So we started with a long escrow period.
Mm-hmm.
And then COVID hit and we're like, well, we can't close now because there's, issues, with obtaining, financing and other things that, were going on. COVID's impacting my client's business and their ability to, fund the purchase and all of that. Right. So, and fortunately the sellers were amenable to extending the close of escrow. So we extended the close of escrow out and kept extending it until we were in a position to be able to close, post COVID. So it was like 4 years and we closed, the sellers were happy. My client was happy. The title company was happy because it was a large transaction. But we waited 4 years to close that transaction. So that just shows you how commercial is definitely different than residential, because you can have these extended escrow periods that you will not find on the residential side.
Well, and one thing that is certainly true, and we're used to this as lawyers, but not only is the due diligence period laden with a lot of due diligence, there's a lot of time sensitivity to it contractually, right? There's hard and fast deadlines that are at stake in a commercial transaction. There is earnest money oftentimes that is on the hook. And those are all things you really got to watch for in a commercial deal.
Well, yeah. And, that really is another primary difference is if you have in the residential setting, most contracts are going to have a cure notice. And it says, hey, look, you have 3 days or 10 days, for the seller to cure you or for the buyer to cure you before you perform. On a commercial purchase and sell agreement, you generally don't have a cure notice. Either you comply with the deadline as a buyer or you lose your earnest money. It's plain and simple.
Right.
Either you close escrow or you lose your earnest money and you no longer have a transaction.
Yeah.
And so deadlines are critical.
Yeah. All right. So our guest, Jeff, our buddy, he apparently we've got things working. So we're going to bring him on. Jeff, can you hear us?
I can hear you. I've been hearing you the whole time. You guys have been having a great conversation.
Oh, well, we're glad you approve. We're we're happy to have you on to talk about commercial deals. Why don't you take just a minute or two, tell our audience who you are and why they should listen to you.
I'm not sure they should listen, but we'll try. All right. So my name's Jeff Watson, and I'm privileged to be friends with these two wonderful characters and a few other lawyers from across the United States that they've pulled together. I'm a lawyer and licensed only in the state of Ohio and only in Ohio. Been practicing about 32, 33 years. I've been a real estate investor for almost 30 years, and I have done some commercial deals, both as counsel for the buyer, counsel for the seller. I've been commercial deals where I'm the buyer myself personally. I've also done a bunch of residential deals where I'm the buyer or I'm the seller, and I've represented a few people, done note transactions, that kind of stuff. And I've done quite a bit of policy work advocating for real estate investors in Washington, D.C. I've had meetings with CFPB, FHFA, Freddie Mac, Fannie Mae, multiple congressional meetings, probably about 250 different briefings, meetings, lobbying sessions with congressional members, Senate members, their staffers, their policy wonks, the whole bit. So I kind of got a feel for a little bit about what goes on with real estate deals. Believe me, I'm not an expert. I'm still trying to figure out how to practice law. But that's a little bit about me.
All right. Well, they do say it's a practice. So as we get older, we're just getting better and practicing more.
I still have to keep practicing. I can't get it right.
Yeah. Yeah. Well, join the club. Well, Jeff, so you've been hearing some of it. We've been talking about these folks, the investors that love the idea of subject to, and the residential world lends itself so well to that. But of course, what does the investor think? Man, how can I do this in the commercial world where the money's bigger? And so we've been talking about some of the hitches, the abilities, and what that looks like, and what you would deal with in the commercial space. We've talked about the types of commercial loans as well as the due diligence periods associated with all that. We're going to talk about acquisition strategies as well. But before we get into that, I know you've heard some of it. Do you have any general thoughts on quirks or issues that you run into with commercial deals, just understanding the loans and so on and so forth?
Yeah, there's a couple of things I'll say, and that is 1 month and 3 days ago, a partner and I closed on a commercial deal where we were the buyers. We negotiated the transaction to where we didn't take it subject to, we assumed the institutional debt of 6.4 million at a 3.25% interest rate. Negotiations. I'm telling you, there is so much that goes into that, folks. The LOI is a great starting point. You've got to be very crystal clear in the LOI, like you guys were talking about earlier. And then it's about conversation after conversation after conversation. We're now in the process, the same partner and I, we're now in the process of negotiating to buy 3 more commercial-like properties, all in that same price band of about $13 to $15 million purchase price. And it's a different world. If you think that your subto strategy for residential real estate is going to easily translate into commercial, no. It's just like if you think that your wholesaling strategies are going to work in commercial, no, it doesn't do it that way. There's a lot more involved, a lot more intensive thought needs to go into it. Yeah.
Did you know going in as early as the LOI period that assumption was something you wanted to do, or did you just fall into place?
We mid negotiations pivoted as the rates were rising. My partner put this deal under contract. First of all, this was a seller she had dealt with in the past, or one of the 2 sellers she dealt with in the past. She'd bought stuff from them in the past. Put this thing under contract in the spring, and by early summer, with the way rates were going, the deal would not pencil. It just wouldn't not pencil. And so went back and said, hey, listen, an only way to make this thing work is if we can take that existing loan subto or assume it with the bank's consent. And trust me, we did it with the bank's consent, because there's no way in the world anybody wants to wake up on a Monday morning and get an angry phone call from the president of the local bank going, hey, I see what happened. I want my money. You got 30 days. And I don't know about you, but I don't walk around with 6.4 million in my pocket. Okay. So we had to line all this thing out, and then the bank was fine with it because they're keeping the original seller on as a continuing guarantor for a period of another 18 months. And then we've got to get this guarantor off the loan, and we'll get that done. So that was a key thing to it. So we changed into this deal as the market dictated it. Just to go back and answer your question. And now in these next 3 deals that we're doing, and believe me, I'm not doing all the work. My partner's, she's carrying a lot of the load. So don't you dare think that I'm trying to take any of the credit, because she's doing more work than I am. She's negotiating that right straight up, right off the bat, just going to the seller and their attorney saying, this is what we're doing. Bang, 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 bang. Here's how we're going to handle it. Here's how we'll put the money into escrow, and here's how the payments will get made, etc. And so we're just doing it straight up now because we know where the market is.
So Jeff, that, we were talking about this a little bit earlier. And I think you've hit on it, which is the idea that on commercial, you tend to find these loans being more small portfolio loans and not, securitized loans. So lenders in that case have a more vested, or the bank has a vested interest, as opposed to hundreds of thousands of investors who own a very small share of, the loan portfolio. And so these lenders are monitoring their portfolio. They're, looking at, they're doing audits and looking at, title records and making sure that, everything's being done the right way.
Yes.
And it seems as though these sellers are more sophisticated, but on the flip side, because the loans are so large, that convincing them to do subject to, as opposed to an assumption, formal assumption with the bank, may be a lot more complicated and difficult.
It is a lot more complicated and difficult. The deal we closed, we had an ultra sophisticated seller, ultra sophisticated. I mean, some of the best legal talent in Cincinnati, Ohio represents him. This guy's done hundreds of, this guy's had tens of thousands of doors under control, ultra sophisticated. These next deals that we're working on, not nearly as sophisticated of a seller. It is a different bank. It's not a local community bank. It's a much larger regional bank. So it's a different construct. And so you're exactly right. These are things you've got to know. You've got to be aware of what your seller's knowledge base is. What are they looking for? You got to be aware of what's in the loan. And the other thing, and I think you guys touched on this when I was struggling with the technical difficulties. Remember, commercial loans have a bigger responsibility on the borrower for supplying updated financials on a regular basis.
Yep.
And so if you think that you're going to get the bank to ignore that, well, I got a bridge in Brooklyn I want to sell you. So that's something else you got to be aware of. And pay attention, folks. But I'm going to go back to one other tip that you said. And this is, if you've heard me speak about subto, I'm a big fan of subto on the right kind of residential property, particularly the stuff that's been securitized and dropped into these huge mortgage-backed securities. I think those are the ones that are ripe for doing subto deals on residential.
Yeah. So talk to us about the negotiations with the small community bank, because here's my experience. So coming even out of the short sale realm, where I worked with a lot of brokers and sellers and others, even investors seeking to buy, the idea of communicating with these large servicers was just a nightmare. And, nobody knew what was going on. You would never get calls back. You would get him and hawed the whole time, even though what you were proposing made tons of financial sense. And I think we have the same thing going on if somebody were to call up, one of these big services and be like, hey, I want to assume this residential loan, and be like, yeah, you're never going to talk to somebody and have a rational conversation. But when you're talking to a community bank, you may be talking to a vice president or a president who actually has decision-making authority. So talk to us a little bit about that and what that, negotiation was like.
So my partner handled all the negotiations, but that is exactly what it was. She dealt with a vice president of the bank, and she dealt with another loan officer that they both were part of the loan committee.
Mm-hmm.
And so they had authority to say yes, no, or here's what we got to research and get back to you with.
Mm.
And so there was no limbo, there was no mumbo jumbo, there was no confusion. It was yes, you can, no, you can't. We want it this way, or we'll give you an answer in 24 hours. And that bank was that way. And they were a pleasure to deal with. Now, at the last minute, somebody stuck in a little gotcha clause, but we kind of knew it was coming.
Mm.
I mean, and so what the lender did is essentially say, hey, listen, we're agreeing to let you assume this thing. We're going to bring you on as a co-guarantor, but we want this thing paid off in 18 months.
Mm.
And that didn't show up until 2 days before closing. And the last version of the loan assumption agreement. And we're like, dang it, we're this far in. we'll get across the finish line and figure it out, and that's what we did. Now, the good news is that property is performing far better than we thought it would. So it's going to make the refi in about 18 months or 17 months from now pretty simple compared. But that is assuming that people continue to believe the current CPI data and the Fed finally decides that, hey, we've killed the economy far enough. We're going to lift the jackboot off the throat of the American public a little bit, let them breathe. Maybe rates will come down. A little bit of a figurative speech there because now you know what I think about the Fed. Anyhow, what I think about a lot of the stuff going on. And I mean, there's I'm not going to go there. I'm just going to say there's bad people on both sides of the aisle there. So I'll just leave it at that. I'm going to be bipartisan in my disparagement.
So Jeff, let's talk about the acquisition and document side of this.
Okay.
Obviously, in your case, an assumption's a little bit different, but if you're trying to take down a commercial property subject to, how is there a difference in what the documentation is going to look like with as opposed to the residential side of things? I think as a general rule, it's pretty similar, but you gave examples of the borrowers in a lending context having to show financials and everything else.
Right.
Now, I guess you can build that into your typical documents, but what does that look like, and is it any different than the residential?
So I'll give you two illustrations. The deal we closed versus the deals we're negotiating right now. The deal we closed, the purchase document was pretty simple. The purchase and sales agreement was very simple. The LLC documents were pretty simple. I drafted the amended and restated operating agreement for the LLCs that were involved and so on. The basic loan guarantee from the bank was boilerplate. I mean, I took a look at the bill that came from the law firm that drafted it, and I was like, man, somebody didn't spend a lot of time on this. It's boilerplate, good to go. So that was pretty simple. The real issue was making sure everybody understood what was going on. That the sellers knew, the lender knew, that we knew, and that the attorneys representing on both sides knew. So it was a lot of communication. And what made this work, and folks, listen to me carefully here, because this may be one of the big takeaways, is we didn't run everything. All my communication did not go just to my lawyer and just to my partner. It went to everybody else in the deal. Title people saw it. The seller's counsel saw it. The bank representative saw it, so that we had clear, open communication. That was one of the key elements that made that deal work. Now that we're dealing with a different property with a far less sophisticated seller and a far different bank, we're focusing on making sure that the purchase and sales document is extremely clear, extremely detailed, with all the angles covered. And we've had a pushback on this one, whereas we've had a conversation about life expectancy of the parties. Everybody's young. I'm the oldest person in the deal, but everybody's young, but there's still a concern. Well, what if somebody becomes disabled? What if this happens? What if that happens? And so we're trying to negotiate around that and draft around that. So there's a lot more thought that goes into these documents than in a standard residential purchase and sales agreement or a standard residential sub-2 contract.
Now, do you think there's more thought put in with regard to the things you've mentioned on the commercial side? I don't think that's unique to just commercial. Is it just because there's more money on the table? We're just talking about a lot more money than we would be talking about in a residential transaction?
That's
or is there
part of
more
it.
to it than that?
There's more to it than just that there's a lot more money. It's also that you're going to be in some sort of a business relationship for a while. That loan's going to remain in the seller's name for years to come. And we've got to think about what happens if their health goes downhill. What happens if they die in a skydiving accident? We got to think about these things. And then we've got to also think about what happens if our businesses shift and change and things like that. So there's a lot more thought that goes into it. And it's not just because we're lawyers and we're making things complicated. It's worth thinking it through, because, I mean, the simplest transaction out there is I give you money, you give me a clear deed, we're done. And we're way far away from that. We're getting a deed that's not clear, and we're not giving them all the money. So it gets complicated. Yeah. Sure.
Well, Jeff, we're always so happy to have you, even if it's only for a couple minutes. You always have great nuggets of wisdom. Tell our listeners what you're up to and how they can connect with you.
Oh, well, I'm up to about 5'10". Got to get some weight off on the scale so I can ride my bike faster. So we're not going to talk about that number, but
so they can find you outside exercising.
Yeah, they can find me on the Pinellas Byway bike trail. That's a good spot to see me. I'm normally on a red and white Cannondale Evo 6 trying to go. But if you want to keep up with the craziness called my life, check out my blog, watsoninvested.com, watsoninvested.com. Articles that I write go up there. I talk about some of the events that I'm either going to be at or I'm speaking at, things like that. So that's one way to keep track of it. But I want to be careful that I don't say more about the deals that we're still negotiating. And we've got some interesting opportunities. I'm just going to tell you, folks, pay attention, because at times like what we're seeing in this economy and in this particular housing market, there is tremendous opportunity for someone who is willing to come at it from a different perspective, put in the extra effort, and find a solution. Because more and more I think about it, I'm not an investor and I'm not a lawyer. I'm just a problem solver. If I can solve the problem, then everybody wins.
Good stuff. Jeff, thanks so much for being with us. Let's do it again soon.
Let's do it again soon. And let's hope that technology doesn't thwart our efforts like it did earlier today. But hey,
we won't let it keep us down. You have a good one, Jeff. We'll see you again.
Thank you so much, guys. I really appreciate you inviting me in. Thank you.
No problem. All right. With that is our episode for today. Make sure to join us in 2 weeks. We are taking next week off. It is Thanksgiving, so we hope that you take some time next week, spend it with your family, and be thankful for everything that God's given you. With that, we'll see you in 2 weeks. Have a good one.
Have a good day, everyone.